Welcome back. We are
I'm going
back.
to talk about private.
Hang on one second, Bonnie. Bonnie and I were having a whole conversation here, and I didn't warn her, but we're back. So let me just introduce. Bonnie Yates is joining us. Good morning, and she is coming to us from the law firm from Hirji and Chow. Let me say that properly. And they're an amazing law firm here in Southern California, in Culver City. And Bonnie, tell us a little bit about Hirji and Chow.
Hirji and Chow is a 6-attorney law firm. We're located in Culver City, California, and we serve individuals with disabilities in a lot of settings. In the public schools, through the IEP and 504 process, in the regional center, for the developmentally disabled, for those who qualify, and then we also represent students in college that have higher education issues. And we also do disability-related civil rights litigation. So we're able to cover a lot of bases because we have, different people that do different things. So is we offer people a complimentary consultation if they're in Southern California. So if you want to know more about what we do, our website is www.lawyer4children.com, and our phone number is 310-391-0330. We do want everybody to know that in legal advice, we're talking to people about their legal rights. If you have a specific legal problem in your state, you need to go to www.copa.net, which is a good place to start looking for a special education attorney. And we do recommend that if you have concerns, you address them sooner rather than later, because oftentimes early intervention is good on the legal front as well as on the clinical front. Anyway.
Well, that's a really good point to make. I said that's a really good point to make. I don't know how often we make that point that, early intervention is key, and that it's key in the education setting, and it's a great argument to be made legally as well as clinically. So thank you for making that point. And we do have questions, Bonnie, and we also, there may be other things that you want to talk about. So which would you like to start with?
Respond to the last thing you said, because I gush out quickly before we get to your questions what I mean by saying early intervention in the legal realm can be important too. If you can get some free advice and learn more about how the IDEA process works, you would be well advised to do that, because what times is, for example, a client will come to me and say, number of IEP meetings that were very illegal, and I say, well, did you record those meetings? And they say, no, we didn't. So it's going to be very difficult to prove what people said. The district will disclaim the things that people said. It doesn't matter if there's some documentation. It's not a substitute for knowing what was on the recording. So in California, the rule is that you can audio record a meeting if you give the district 1 day, 24 hours written notice. And people are reluctant to do that, because when they start to record meetings, oftentimes the district will push back and say, are you sure you want to do that? And you're making this adversarial. I can't emphasize enough how important meetings being recorded is. Similarly, people get in these kind of free and easy communication school, and they're parents of young children, and they're busy. But conversations that you have with somebody that are not memorialized in writing are not going to help you after the fact. So that would be alone two things that people, if they came in and sat on and talked about what they should be doing. And the discussion goes from there. And the hard part for me is I get a lot of people coming in and saying, what would be a better district to move to?
Yeah.
And then I have to explain to them that even in the affluent districts in Southern California, the systemic problems are the same. because we've got an underfunded mandate and people that went into special education to be helpful, and then they crash into the fact that there aren't enough resources to go around, and that promotes a kind of behavior that can be misleading and not helpful. And to some extent, parents have to have that experience, that aha experience of realizing that the way the system is described as versus the way the system actually functions are not the same. And that's a hard realization. The last thing I'm going to say is, frequently I'll have extended conversations with a parent. They'll decide they're going to retain our office to represent them. And then something happens, like the district will offer a different placement, or there'll be some adjustment that's, attempted. And more times than not, that person's situation is still not going to resolve and they're going to come back later. But it's always good to know as much as you can about this process. And we view ourselves as wanting to fulfill IDEA's mandate, which is to create informed parents that can self-advocate. So that's why we want to spend time with you, because we want you to understand, for example, that there's a very strong thread running through the IDEA that parents are supposed to receive informed consent so they can participate in an informed way. And that's why I talked last week about prior written notice. So that's why it can be good to collaborate early on. And remember, just because you go and talk to an attorney does not mean you're going to take adverse action against the school district. That's not what it means. It just means it's a way to get your legal questions answered in a legal manner. If you go and ask the principal what the rules are, I can guarantee that person is going to give a different answer than me. Well, I can't guarantee it, but it would be probable.
Hey, thanks for watching Autism Live. To subscribe, click here. And if you'd like to check out some more of our videos, click here.